This is Justice Alito, and he wrote the opinion for a 5-4 decision called Burwell v. Hobby Lobby Stores that was decided in 2014. This case has to do with the Affordable Care Act and a religious exemption regarding reproduction or contraceptive health care for women when a for-profit corporation is involved. Here's what happened. Hobby Lobby was a for-profit organization, and they claim they are a closely held, family-owned corporation. And because of this, they have certain religious beliefs that should be respected. And one of those beliefs had to do with contraception when it came to health care for women. Now, the Affordable Care Act had put into place a requirement that businesses needed to have health care options available for employees. And this is a long and complicated situation, but what had happened previously was that nonprofit organizations had already been told that there are some religious exemptions when it comes to healthcare questions and corporations. But these were nonprofit corporations, and Hobby Lobby was a for-profit corporation. Now, they didn't want to have to offer any kind of health insurance or anything regarding conception. All the way up to the U.S. Supreme Court it went. Hobby Lobby came in and said, this violates the First Amendment of the Constitution, and we, a closely held family organization, should have grounds for standing to bring this case because it violates our freedom of religion. So standing was a key issue to this case. And Justice Alito came in and said, look, we're talking about a bipartisan Religious Freedom Restoration Act of 1993, where we've got a strict scrutiny test involved. Now, when it comes specifically to this issue of contraception and religion, under this act, nonprofits were already granted this exception. And so we're going to go ahead and give that exemption then to for-profit companies like Hobby Lobby. Oh yes, there was standing to bring the case, and we do need to apply strict scrutiny, but here the government is not using the least restrictive measure possible. There are other ways for healthcare and contraception to be obtained by these women employees. And so because of that, they did not pass the test, meaning Hobby Lobby won their case and did not have to offer any kind of healthcare that involved contraception based on their religious beliefs. This is a very narrow reading, and it has not overturned the Affordable Care Act. It's just allowed for profit organizations to be included in the exemption that had already been set out. So there would be no tax penalties for Hobby Lobby. They won their case.